A very, very good evening to all of you, friends. A very, very good evening to all of you. Welcome to this very, very important session insofar as your preparation for AILET 2023 is concerned. The most expected question in AILET. Now, before I begin, let me just absolutely in clarity tell you that in case a student wants to get into NLU Delhi, which is one of the top law schools of the country, their admission test is a different test, and that is AILET. Now, if you crack AILET, you get an opportunity to be in the top law school of the country situated in Delhi. Now, the advantage of NLU Delhi is the fact that it's situated in Delhi, where the High Court, the Supreme Court of India, the most important commissions of India, national commissions, are all situated here. Lawyers of Supreme Court, judges of Supreme Court, judges of the Delhi High Court go and visit and give guest lecture in this particular law school. Of course, they also travel across the country and give lectures. But since you get a geographical advantage that exists, I would always say yes, it is one of the top law schools of the country. Prepare well and give this examination. Okay. Now, in this session today, friends, I'm going to talk to you about number one. I'm going to solve with you some very, very important questions. Now, these questions are not passage-based questions, but principle and fact-based questions. Right? Now, the kind of questions you get in CLAT is little different from the kind of questions you get in AILET. Now, what is the difference? The first difference is, insofar as CLAT is concerned, they give you a particular passage. They tell you, yes, this is the particular passage. Read the passage, understand the passage, and based on the inputs that you get from that passage, solve these questions. Now, AILET has a little different approach. Now, what is the kind of questions that come in AILET? Now, the kind of questions that come in AILET is simply principle and fact-based question. That means there would be a legal principle. There would be a legal principle somewhere. You need to understand that legal principle, refer to the facts, and then come to the correct option. Let's start solving. Okay, let's start, because the moment we start solving, we better understand the kind of questions. Okay, now there are certain passages. There will be around 25 questions. Okay, there will be around 25 questions for today, and let's start solving. Okay, the first question before you, but prior to that, BYJU'S Exam Prep brings to you an exam prep test series. So we have a test series for CLAT and other law entrance examination, which has 45 mocks, 20 CLAT, 25 non-CLAT mocks, 9,000 practice question, topic test covering every subtopic, 3 All India mock with video solutions, a detailed mock analysis. This test series is prepared by NLU alumni, and this is all based on the actual exam pattern. Those of you who haven't got it, please get it now, because you just have around a month left. The more mock test you give, the better it will be for you. Okay, so Let's start. Okay, there are certain legal principles, there will be facts. You need to apply the legal principle onto the facts and select the best or the most appropriate answer. Yes, on the screen, please read it. Is that clear, everyone? What is this duty of care? Voluntary non-fit injuria. If you voluntarily take up a risk, you know that that risk involves some harm to you. Even then, you take up that risk. Later on, if you suffer an injury, you cannot claim any compensation. That is the principle of voluntary non-fit injuria. The factual situation, owing to the negligence of the contractors engaged in repairing the roof and a portion of the glass fell and stuck Anil, causing him severe shock. Reena, please read it. Is that clear, everyone? Am I clear to each and every one of you? Brilliant. Okay. Yeah. Is the defense available? Is it not available? Is it available only to the husband? Is it available only to the wife? Or is it available both to the husband and the wife? Is the defense of voluntary non-fit injuria available or not available? Can the shopkeeper say voluntary non-fit injuria, you cannot claim compensation? The answer is absolutely right. Option D. It is not available in respect of both the husband and the wife. It is not available at all. It is not available at all. Am I clear? The doctrine states that if someone willingly places themselves in a position where harm might result, knowing that some degree of harm may result, they will not be liable to claim compensation. But glass fell and stuck Anil, causing him severe shock. And the facts very categorically say that there was some breach of duty on the part of the contractors. Is that clear? Is that clear, everyone? Am I clear to each and every one of you? Please tell me that. Okay, good, good, good. Let's move on. Question number 2. Read the question very carefully. And this is a common for both question number 2 and 3. Okay. Okay, is that clear? Let's read the factual situation. A tannery was there 3 miles. Reasonable foresight. Now, suppose someone is drilling water for consuming purpose. And 3 miles means 9 kilometer. Around 9 kilometer. There is a tannery. Now, can the tannery people expect that owing to that tannery, water which is drilled around 9 kilometers away can get contaminated? Keep that in mind. Okay. Fast. Is the damage foreseeable or not foreseeable? The question over here is simply this. Is the damage that is caused 9 kilometers? Could it be foreseen by the tannery people? Could it be? The correct answer is no. The damage is too remote. Too remote. It is not possible for the tannery owner to be reasonably foresee a spillage eventually lead to contamination of water so far away. 3 miles. Okay. So the correct answer is option B. Okay, sorry, 4.5 kilometers. Not 3 miles is 4.5 kilometers, approximately 5 kilometers. Okay, it's not possible. 150 meters I can foresee, but 4.5 kilometers? Holy God. The next question, question number 3. Same principle, foreseeability and all. Okay. Okay. Yeah. The question is up there on your screen. The question is up there on your screen. Yeah. The correct answer is the interference with the television signal caused by the construction of the tower could not amount to private nuisance. Effective town planning can sort this matter instead. Is that clear? Is that clear? Everyone? Unlawful, indirect interference. Is that clear? Television signal. Keep that in your mind. Now, dust and noise can be public nuisance. Can be dust and noise, but those signals, TV signals, that cannot be. Is that clear, everyone? Everyone. TV signals is a separate issue altogether. Question number 4. Okay? Read the facts. Is that clear, everyone? Okay? There is a verbal spat, over Twitter, social media against two people. Okay. Yes, your options. Are the tweets defamatory in nature? Insofar as whether it lowers the respect of the other in the eyes of third party, whether those tweets are just normal tweets, does not have any defamation attached to it. The correct answer is both the tweets, both Anishka Chauhan and the other, they both have said something wrong against each other. Is that clear? Is that clear, everyone? So are you guys understanding how to solve these questions? Very good, very good. Both the tweets, both these two tweets, somebody is calling someone a social anthrax. So both the tweets are defamatory in nature. Question number 5. Okay, everyone. Yeah. Now, suppose someone comes to my house and I know that, one of my bathrooms, one of my washrooms has some particular defect. Okay. If you stepped somewhere, okay, there is some water leakage or some problem. Is it my responsibility to tell the guest that, sir, madam, there is some problem, don't avoid that area? Yes or no? Is that clear? Is that clear to everyone? Very good. Okay. Question number 6. Okay. Yeah. Options. Okay. Let's read option C and D. Okay. What is the correct option? The union was guilty for the tort of intimidation. It was unlawful intimidation to use threat to break the contract with their employer as a weapon to make them do something which was legally entitled. So the correct answer is option A. Is that clear? Everyone. Let's read question number 7. Okay. Okay. The facts. You write something in the prospectus. You write something in the prospectus which you do not possess. People see your prospectus, oh my God, and start investing on you. Now, one very important thing that you must remember, was it intentional or was it not intentional? Mind you, the company, the board was concerned for the formality. They thought that it is just a formality. They will get it later on. Now, keeping in mind, in criminal law, it might be something else. In criminal law, your answer might be something else. Mind, we are talking with law of tort, law of contract, civil law. What is your correct answer? The correct answer is the company is not liable because it was incorrect, but not fraudulent. They never had the intention. No intention. Is that clear? There was no intention to defraud people. Okay. Question number 8. Suppose you buy a house next to a golf course. People are playing golf. Those balls will come. Hang on. Just an example of cricket over here. Okay. She does not want compensation. She says that I want an injunction, a permanent injunction. And nobody can play cricket. Nobody can play golf. Right. Okay. Okay. Let's decide. Somebody suffers some harm. Of course, she is entitled to compensation. There is no doubt that she is not entitled. She is definitely entitled to get compensation. But can an injunction be passed? A little far-fetched. Am I clear? She is entitled for compensation, but not to get an order of injunction, my dear. Is that clear? Question number 9. Okay. Read it very carefully. if you bring on your land something dangerous that escapes, here is this water pipe and here is a gas pipe. There is a leakage which was undetected for some time. It's a high pressure gas pipeline, right? There's a serious and immediate risk to life. Let's decide. Is the council liable? Is the council not liable? Just stick to the principle. Read over there. It was non-natural nor dangerous use of the land. Is it non-natural to put a gas pipeline? Is it unnatural to put a water pipeline underneath the earth? Thank you. Please do not get swayed away by the facts. Please do not. The moment you get swayed away with the facts, danger arises. And when I say danger arises, I talk of you have a high chance of committing an error. High chance of committing an error. Is that clear? Okay. Question number 10. Okay. Question. Okay. Somebody is producing a particular medicine for which someone has caused some cancer. Now, this mother company has 90%, it produced 90% of the total manufacture of the drugs. The correct answer is yes. The chances of the actual tortfeasor escaping liability is greatly reduced. 90% of the out of the 100% drugs is created by this mother company. Is that clear? Everyone. Question number 11. Which would be the strongest argument that Himanshu can make? 50,000 rupees a piano with some defect, he wants to exchange it. Says, no, I'm not going to. The best statement insofar as the shopkeeper is concerned. The shopkeeper. The best argument is Himanshu is not liable because he gave only Kritika his opinion, his advice. But he did not make any false statement of facts. Did he make any false statement insofar as the facts are concerned? No, he did not. Is that clear? So I'm being a little fast because we have to solve a number of questions. Yeah. A confession before a police officer, is it of any real value? A confession made just to a police officer is of no value. Everyone knows it, I think. Absolutely, each and every one of you are aware of it. I don't have to say all these things, right? Yeah. Okay. Chalo. Let's move on. 13. 13. Okay. Okay. He's the real owner. Oh my god. Okay. Okay. When the real owner comes, he stops paying to someone else. Very interesting. As per the contract, whom did she had to pay? Whose property it is? It's something else. It's outside the scope of contract. That's a title dispute that can be decided by the civil courts. Am I clear? Am I clear to everyone? Okay. Okay. Yes. voluntary non-fit injuria. But did Q had the knowledge about the risk insofar as that driving of that bike or that vehicle is concerned? No. So option D is the right answer. Option D is the right answer. Is that clear, everyone? Is that clear? 15th question. To determine whether an act falls within the scope of employment, okay, or functions work of the employee was tasked with and then evaluated close connection between the employee's job function and the wrongful act in question. Very good. G was employed as a security guard by a restaurant. He was tasked with maintaining security of the restaurant, escorting guests inside. One night, after G's shift, a group of unruly passerbys irritated in altercation with G near the restaurant. Greatly upset by the altercation, G went his home and in a state of intoxication. He negligently caused fire in his home. G's family member wished to make the restaurant liable. Oh my god. How is a restaurant liable? The restaurant is not liable. Outside the course of employment. Outside the course of employment. It is outside the course of employment. Very simple. Is that clear? Everyone? Is that clear to each and everyone? Now, what I do over here, there are another 10 more questions, okay? 10 more questions. But there are also successive classes happening in our YouTube as well as in other platforms itself, okay, right? So, do we continue with more questions or do we stop here? We can have the rest questions in some other class because it's a 45 minutes is over and a lot of students might have some other classes at 5 o'clock, 6 o'clock in the paid channels. Yeah. Do we continue or do we stop? Whatever you say. Okay, we can continue. Okay. Brilliant. Great. Fantastic. Okay. Let's continue then. Passage number 16. Very similar, but over here, G being short-tempered got irritated and ending up hitting one of the guests. Is the restaurant liable? Very easy. Very easy. The restaurant is absolutely liable because it was done during the course of employment. It was done during the course of employment. Okay. 17. You hide something in someone's ceiling. That man will never find it out. Is it theft? Yes, it is theft. It is theft. It is theft. There is no doubt about it. It is theft. Did you all understand? Are you understanding how to solve these questions? $18. Can you steal your own thing? Suppose I have given my mobile phone to repair in a shop. The shopkeeper is not there. I take my mobile phone from his shop. Have I committed theft of the mobile phone? Tell me what is the correct answer. Tell me. Yes. Okay, the correct answer is option D. Now, over here, it is difficult to conclude that the watch was with the possession of the jeweler or not. And that is the reason. That is the reason. Or else, generally, the answer A should have been the right answer. But to this answer, option D is the right answer. I understand. Little confusion in the facts. Am I clear? Did you understand now? Did you all understand now? Good. 19. Can it be called a criminal trespass? Suppose I enter my neighbor's house tomorrow. Can it be called a criminal trespass? It is not a criminal trespass. It is not. Okay? 20. Does this amount to bribery? Stick to the principle. Stick to the principle. Don't look here and there. Just stick to the principle. Has he committed bribery or not? Yes, he has. And why? Because by showing the party symbol, he made it evident that he wanted to induce the family to vote. And that is why he helped them. This is a clear case of inducing a person to vote for payment of money, may be life-saving drugs. Is that clear? Is that clear to each and every one? Okay. Is that clear? Any doubts? Okay. Okay. 21. Okay. Okay, clause A and B. Okay. Let's see. Let's see. Okay. Option D is the right answer. Combination of both option A and B. Earthquake, natural disaster, could not be delivered. Goods could not be delivered because of the earthquake. Uh, 22. Jurisdiction of a court. Okay. Delhi, Kolkata. Delhi, Kolkata. In Delhi only? No. Both in Delhi and Kolkata could have been the right answer. In Kolkata, assuming the dispute arose in either Delhi and Calcutta, assuming the dispute arises in Calcutta? No. If the dispute arose in Calcutta, you have to go to no, none of the. Amongst the four, the B is the best answer. Might not be the absolute best answer, but amongst these four, B is the best answer. Because of this part, option C is not the right answer. Because this part. Is that clear? Oh, sorry. Let me just read once again. I'm really sorry, guys. I'm really sorry. I think there is. What does it say? I was also in a hurry. Anywhere, Delhi and Kolkata. Sorry, it is both Delhi and either Delhi and Calcutta. Assuming I read it wrongly. Sorry, both Delhi and Calcutta has to be the right answer. Both Delhi and Calcutta. Okay, yeah. Either in Delhi or in Kolkata. Okay. Okay. Question number 23. Okay. Yeah. X, Y जहां रहता है and the dispute. Okay. Okay. Both again in Delhi and Kolkata again because these are the two places. X reside, Y reside, and the place of dispute. Very easy. Oh, I just got that answer in a hurry because, I have another class back. Okay, I have to take another class in another 5 minutes time at 24. Okay. What's the government? Okay, issue license. Okay, issuing license to meet a particular criteria. Applied for driving license to meet an oral agreement. X will pay 5,000 to issue to Y. Okay. Okay. I have entered into a contract with Y. Okay. A contract to get a license. Is that clear? Is that clear? This one, it is not enforceable. It can't be. Doing something wrong. Anyone who pleads on behalf of other in a court is a pleader. All lawyers are pleaders. Okay, this is okay. Anyone who pleads on behalf of another in a court is a pleader. Okay, all lawyers are pleader. Okay, all pleaders are lawyers. Okay, X, a lawyer, pleads his own case in a court. No. Okay. X is a pleader in this case. Okay. X is not a pleader in this case because he is pleading on behalf of another. Okay. As long as he's a lawyer, X is a pleader in all the cases. All pleaders are lawyers. To my understanding, option C should be the right answer. Let's see. Option C, to my understanding. Yes, because this is all those reasoning question which Krishnendu sir and all generally take. This is just given in law, that's why. Okay, so guys, I hope you understood this session. Okay, I hope. Now, BYJU'S Exam Prep brings to you the last lap to CLAT 2023. 25 power pack session, must to do topics, practice questions based on the latest exam pattern, practice solving skills and tips. So guys, these are the dates started already. So guys, do like this session, and there is already a open mock test which happened between 5th and 12th of November. So these are some of the important schedules. So today you had this legal questions for AILET by me. Similarly, you will have a number of series, 25 power pack sessions. Do subscribe to our YouTube channel. Do follow us on our Instagram. Do like our Facebook page. Do join our Telegram channel. And just do not forget to download the BYJU'S Exam Prep app. With this, we come to the end of this session. Thank you very, very much. I hope you enjoy it. Do share this session with your friends. Bye-bye. Take care. Okay. Thank you. Bye-bye. Take care.